Good afternoon and welcome. I'm Jane Harmon, the president and CEO of the Wilson Center, and very proud to open this important event. Let me recognize Minister Christian Vargas, Chargé d'Affaires at the British Embassy. We have many other... You know, it's funny. Thank you, Paolo. What would I do without Paolo? I guess I had this new election in Britain on my mind, but I should focus on Brazil, the Brazilian embassy. And it's an honor for us to host Brazilian federal judge Sérgio Moro this afternoon to discuss his experience handling some of the most sensitive and important corruption cases in Brazil's history. No one has missed that Brazil is confronted with a serious political and economic crisis, made more complex by continuing investigations of leaders at the highest levels. The Wilson Center's Brazil Institute, ably led by Paulo Sotero, to my left, has been at the forefront of this issue for a long time, both explaining these developments to our audiences in the United States and around the world, and trying to recommend actionable ideas for change. For years, Paulo has organized exchanges between U.S. and Brazilian judges to discuss rule of law best practices at the Law Library, at the Library of Congress, some of which I've attended personally. I don't think any other group in town has been on this rule of law issue as long as we have, and Paulo was our original leader on this issue. We've taken the lead, and earlier this year, the Wilson Center launched a global initiative on combating corruption. Stay tuned. Back in 2011, Paulo gathered 4 members of the Brazilian Supreme Court, including then Chief Justice Cesar Peluso and now current Chief Justice Ricardo Lewandowski, for a productive conversation. U.S. Supreme Court Chief Justice John Roberts also participated. It couldn't have happened at a more important time, in the lead up to a number of major corruption cases starting in 2012. That meeting was the beginning of a sea change. According to recent opinion polls, 9 out of 10 Brazilians say they support continuing the Petrobras investigations, even if it causes economic pain, a case Judge Moro is presiding over. That's amazing, and it has a lot to do with the courage of young people in Brazil. Also here with us today is Brazil Institute and dear friend, Brazil Institute board chair and dear friend and former ambassador to Brazil, Tony Harrington, who will introduce Judge Moro. I'm also pleased to have with us senior federal judge Peter Macete of Maryland, who has worked for years with our Brazil Institute on programs like the one that brings Judge Moro to Washington. And let me say, on a personal note, that Michael Darden, right there, who has never looked so dressed up in his long career at the Wilson Center, just told me that this is his last formal event here because he's headed off to the Duke Graduate School of Public Policy. And I'm very upset to hear this because Michael Darden is a fixture here. He's also the way our softball team wins its matches, or its games. So to Michael, farewell, and thank you for your enormous service to the Wilson Center. So, with great pleasure, let me reintroduce Ambassador Tony Harrington, who will introduce our speaker.
Thank you very much, dear friend Jane, and thank you for the leadership you provide this important institution. Good afternoon to all of you who've joined this very important occasion, some in an adjacent room, and a large number, I'm sure, watching online. It's a pleasure and an honor for me to join in welcoming Judge Sérgio Moro to Washington and to the Wilson Center. We're also always glad to have Senior Federal Judge Peter Macete long a friend of Brazil and of the Brazil Institute. Judge Massetti was with us last week for the launching of a lecture series on the rule of law in Brazil, co-sponsored by the Brazil Institute and the Washington College of Law at American University. The judge leads a program at the law school that fosters dialogue and cooperation among judges, prosecutors, and legal experts from both our countries. On the occasion last week, Minister José Antonio Dias Toffoli of the Brazilian Supreme Federal Tribunal cited the important work that Judge Moro and others are performing. He also emphasized that the progress in the fight against corruption in Brazil is the product of a strong commitment of Brazilian legal institutions and, as suggested by the poll that Jane mentioned, demand of Brazilian citizens for advancement of the rule of law by affirming accountability and ending impunity. I suspect Judge Moro would agree with Minister Toffoli. This is a truly exemplary ongoing effort in Brazil, and it's an inspiration for the Brazil Institute's program, highlighted by this opportunity to hear from Judge Moro today. When I was ambassador in Brazil, I had the opportunity to conclude a mutual legal assistance treaty between our countries that had long languished. I understand the agreement fell out of favor for a while, but has been revived in recent years to allow for the timely exchange of information between Brazilian and U.S. federal law enforcement officials and prosecutors in the fight against transnational crime. As we all know, this is a time of political, economic, and institutional challenge in Brazil, but it's also a critical time for affirmation of the rule of law in Latin America's largest democracy. Today, Brazil is facing a corruption scandal on an extraordinary scale. Yet, we must applaud the determination of the country's independent judicial, prosecutorial, and law enforcement institutions, which are demonstrating the will and capacity to confront this tide of corruption and hold accountable those responsible. I personally share the view that Brazil will come out of this crisis stronger and hopefully serve as a model for other nations. In regard to the economy, we know that confidence in the rule of law, the extent of the adherence to the rule of law, is a major factor in attracting business, investment, and associated job growth. So it has its economic benefits as well, I would say. Our speaker today, Judge Moro, has been central in these efforts. He earned his Bachelor of Law degree at the Maringá, close?
Yes.
State University in his home state of Paraná, and became a federal judge only 1 year later in 1995. Judge Moro complemented his legal education by studying abroad as well, including at the Little Harvard Law School. In 2002, he received a Juris Doctor degree from the Federal University of Paraná. In his limited spare time, I doubt there's much of it now, as a federal judge, he has also served as an adjunct law professor. Before being called to preside over the so-called Lava Jato criminal trials regarding corruption involving the state oil company Petrobras, Judge Moro had handled other high-profile cases. These cases involved the prosecution of dozens of individuals accused of money laundering, tax evasion, and other federal crimes. So at the request of one of the Supreme Court ministers, as justices are called in Brazil, he worked as an auxiliary judge in the so-called Mensalão case, which revealed an unprecedented vote-buying scheme in the Brazilian Congress and concluded in 2012. Today, Judge Moro will talk to us about the Petrobras judicial proceedings, over which he's presided now, I believe, for some 26 months. Vacation, hopefully, either coming or has had. As a result of his work, which also involves a large team of law enforcement officials, prosecutors, and colleagues on the federal bench, he has become a household name in Brazil and admired not only there but also abroad. Recently, Time magazine named him one of the world's most influential people of 2016. So it's a privilege for us today to hear from Judge Moro regarding the Lava Jato proceedings and the associated advancement of the rule of law in Brazil. After his presentation, Judge Massetti will offer some comments, and then Paulo will invite your questions. Thank you, Your Honor, for joining us in Washington this afternoon, and please join me in welcoming Judge Sérgio Moro.
Good afternoon, ladies and gentlemen. First of all, I want to thank Mr. Paulo Sotero for the invitation and for the opportunity to speak here in Wilson Center. I'm grateful also to Ambassador Antonio Harrington for his kind introduction, and to Judge Peter Massett and the Washington College of Law at American University for sponsoring this presentation on handling political corruption cases in Brazil. It's a great honor and a pleasure to be here. I prepared some written remarks to explain Brazil's criminal justice system and the Lava Jato operation. I'll be happy to answer questions after I speak and Judge Massett offers his comments. I apologize for reading the text of my lecture, but I'm not so comfortable with my English to do it without the support of a written test. First, let me say a few words about Brazilian criminal justice. I presume that most of you are not familiar with it, and that sharing some basic information will help you understanding later Lava Jato operation. I'm not an investigating judge. We don't have in Brazil anything similar to that, which would be the equivalent of the juge d'instruction in France. The police has the responsibility over the investigation of a crime. In this task, the police works with the prosecutor's office, which we call the Ministério Público. Our Ministério Público is comparable to the Fiscalia in the Spanish system. Prosecutors are responsible to produce, present, and sustain in court criminal charges or the accusation against one or more defendants. I'm a federal trial judge, one of many, working at the first instance in Brazil, in a role that corresponds in the United States to that of the district federal judge, like Judge Peter Massett. Criminal cases are tried and sentenced in Brazil, usually by a trial judge sitting alone. He or she is a professional career judge. To become a judge, you have to pass a series of public tests. In Brazil, we have jury trials only for murder cases. After a sentence, the accusation or the defense can submit an appeal to an appeal court. Our appeal courts meet as a panel of career judges, usually 3 or 5. The party that loses an appeal at this level is entitled to present a special appeal to one of our superior courts in Brasilia, the Federal Supreme Tribunal, equivalent to the Supreme Court in US, if the case involves a constitutional question, or to the Superior Court of Justice, if the question raised on appeal involves a federal statute. It usually takes a long time to reach a final decision in complex case, if the accusation or the defense submit all these appeals. Especially to the superior courts in Brasilia, because these courts already have a heavy caseload. The trial judge, like me, has also other responsibilities. For example, only he or she can order pretrial detention or authorize wiretaps or searches and seizures. Only a judge can authorize the lifting of bank secrecy protections and requests bank records during an investigation. There are some few exceptions, but this is the general rule. So even before the trial, the judge can be involved in the case. If one or more of the steps I just described are deemed necessary to the investigation. In this scenario, however, the judge plays a passive role as he or she decides over the requests from the police or the prosecutors. Until recently in Brazil, the enforcement of a criminal conviction was possible only after the case reached a final decision that could no longer be appealed. Enforcement of a criminal sentence depended on the judgment of the last appeal. Only then the case would be seen as transitado em julgado, that's a Brazilian expression, or tried with no possibility of being appealed again. In many, if not in most cases, it could take more than 10 years to reach a final decision because of the heavy caseload I mentioned before. Our Supreme Court ruled in this way in a 2008 decision regarding a controversial interpretation of presumption of innocence in Brazilian Constitution. Of course, as in United States and other countries, the judge in Brazil can order a pretrial detention if the defendant presents a danger to other individuals or to the society, or if there is a risk that the defendant will flee or obstruct justice. I'm aware that the United States Criminal Code also allows a judge to order pretrial detention or deny bail if there are similar risks. If I'm not mistaken, the United States Supreme Court ruled in United States versus Salerno that this statute was constitutional. Pretrial detentions are, of course, exceptions and not the rule. It's also necessary to explain that in the Brazilian judicial system, the Supreme Court has original jurisdiction over criminal charges involving high federal official authorities like the president, the vice president, cabinet ministers, and members of the federal Congress. So in criminal investigations, if investigations produce evidence of criminal conduct by a federal congressman, for example, the judge has to send the case to the Supreme Court. But, as I already said, our Supreme Court has a heavy caseload, which makes it very difficult to have these criminal charges adjudicated in a timely way, as mandated by the Constitution and expected by the public. In Brazil, like in the United States, we have federal courts and state courts. Federal courts have jurisdiction over cases involving federal questions like, for example, crimes committed against a federal institution or a federal company. This is, in general lines, a description of the Brazilian criminal justice. As a rule, let's be clear, it does not work very well in complex cases, especially in white-collar crimes, including bribery and money laundering cases. Two main reasons. First, the slowness of the whole judicial process delays the final judgment and negatively impacts the chances of a serious enforcement of the criminal law in complex cases. In this sort of cases, it was very common that you never saw a final decision, even in cases in which defendants who were accused and found guilty in a case of first instance of very serious crime, including, for example, taking millions in bribes. As a rule, these defendants will never go to prison. Second, the second main reason, because of the heavy caseload, the special jurisdiction of the Supreme Court over criminal charges involving high official authorities worked, as a rule, like a strong shield against the effective accountability of the people in high places. Things start to change in a famous criminal case decided by our Supreme Court 4 years ago in 2012, like Mr. Antonio Harrington said. In criminal case 407, also known in Brazil by mensalão, our Supreme Court convicted highly placed politicians, including a former chief minister of the federal government and several congressmen, political leaders, political parties, operatives, and bank directors accused of bribery and money laundering. These verdicts marked a clear break with a past of weak enforcement of the law against this kind of crimes and criminals. Well, 2 years later came the Lava Jato operation. Let's start talking about it. I heard that here it's called car wash or jet wash operation. But I prefer the Brazilian named Lava Jato, which has a double meaning. Later in the questions, I could explain the double meaning. Okay. Lava Jato operation is not a single case. Its core is the Petrobras scandal involving bribes paid in multiple public contracts to close to 100 people, maybe more. In this case, the prosecutors decide to pursue separate charges against dozens of defendants. So there is not a single accusation, but several. Part of them have already been tried. Part are pending cases. Of course, as a judge, I cannot say much about the criminal cases still pending. I would add, I could say nothing about them. But I can share some of my reflections about the cases that I have already tried. As it usually happens in criminal investigations, Lava Jato started small. The federal police was investigating 4 individuals involved in what seemed to be, at the time, a money laundering crime and illegal financial operations in the money exchange black market. One of these individuals, named Alberto Youssef, had connections with a former director of Petrobras, named Paulo Roberto Costa. Petrobras, to those who don't know, is a big federal-owned Brazilian company responsible for the exploration of oil and gas. It's a major state entity in Brazil. It's our country's largest company and one of the world's largest oil companies. In March of 2014, I authorized search and seizures in the offices and house of these 2 individuals. When I learned from federal law enforcement officials that Paulo Costa had tried to destroy or to hide paper evidence from these searches and seizures, I ordered his pretrial detention. Alberto Youssef was also arrested in pretrial detention for different reasons. Looking at the bank records of Alberto Youssef Enterprises, police and prosecutors discovered that his accounts had received millions in credits from some of the biggest Brazilian construction companies. These companies were also major suppliers of Petrobras. In another line of the investigation, it was discovered, with the assistance of Switzerland authorities, that Paulo Costa had millions of dollars deposited in offshore accounts in Swiss banks. This is how the investigation started. Facing long prison terms, Alberto, Youssef, and Paulo Costa agreed in the second half of 2014 to make plea agreements with the prosecutors. In summary, they revealed that, as a rule, in every contract Petrobras had with top Brazilian construction companies, these companies paid kickbacks of 1 or 2% of the total value of the contract. Alberto Youssef was in charge of organizing the financial scheme. Paulo Costa received a share of the bribes, and a share of the money went to politicians, including federal legislators of the Popular Party, which was part of the ruling coalition. Politicians of the Popular Party had nominated Paulo Costa for his job at Petrobras, so they received a share of the bribes. Youssef and Costa also revealed that other Petrobras officials had received bribes and had worked with intermediaries and politicians of other parties of the governing coalition, such as the Works Party and the Party of the Brazilian Democratic Movement. The investigations continued to produce new evidence, including from plea agreements with other cooperating criminals. Of course, everything that a cooperating criminal says has to be supported by additional evidence. In that regard, there are lots of investigations still underway. But it has been possible in some cases to get evidence which supports information revealed by cooperating criminals. Some critics of the Lava Jato operation say that it depends too much on information obtained under plea agreements. The truth is that the case involves the use of several other investigations methods. The old strategy of following the money remains the most important method of investigation. Especially important in that regard has been the legal suspension of secrecy protections of bank accounts used by these criminals, usually in combination with front companies or strawmen, and an extensive examination of banking records. International cooperation, this is very important, was extensively used to discover secret accounts that Petrobras officials and politicians maintain abroad. It's true, however, that sometimes the only people who served as witness of complex criminal conduct are those who are themselves involved in the crime. With plea agreements, the prosecutors and the police could turn each accused against the other and break the secrets over complex criminal conduct. Looking at the cases already tried, there have been to date about 11 sentences which were specifically related to crimes of bribery in contracts involving Petrobras. In 8 of them, the persons convicted were top executives of the biggest construction companies, top executives of Petrobras, as well as intermediaries between these two groups. 4 former directors of Petrobras have been convicted and sentenced to prison terms. 2 of those decided, after serving part of their prison sentence, to cooperate with the investigation. The police and the prosecutors discovered that all 4 of them had offshore accounts with balance of millions of dollars in countries like Switzerland, Monaco, and Luxembourg. In at least 3 cases, there were convictions of former federal legislators who had received bribes in the Petrobras scandal. In a 3rd case, it was proven that money from the bribes had been directed to illicit financing of a political party. An interesting fact is that two of these former federal legislators who were convicted in Petrobras scandal had also received bribes in the Mensalon case. The investigation unveiled that they received bribes from Petrobras scandal even as the trial of the Mensalon cases by the Supreme Court was going on. That was very disturbing. To illustrate the magnitude of this corrupted practice, a manager at Petrobras, after reaching a deal to collaborate with the authorities, agreed to return nearly $97 million in bribes that he had received from Petrobras contracts and kept in secret bank accounts in Switzerland. In the beginning, Petrobras assumed a posture of general denial. It did not recognize any problem of governance. We don't have any problem, as they said. As the investigation developed, the company gradually started to admit that crimes were committed. This culminated in an official recognition in the 2015 annual report to shareholders of losses from corruption of nearly 6 billion reais, about $2 billion at today's exchange rates. It took time, but after a while, to their credit, some of the construction companies involved in the scheme began also to recognize their responsibility. Two large Brazilian companies reached leniency deals with the prosecutors. They committed to review illicit acts, to abandon criminal practice, to implement efficient systems of compliance, and to compensate public coffers by returning more than $500 million. The more troublesome aspect of the case was that it seems that payments of bribes on Petrobras contracts was not an exception, but rather the rule. Some of the cooperating criminals used that word. They described the crimes they committed as a rule of the game in contracts of the public sector. A rule of the market, some of them also said. Some of them stated that this criminal practice went beyond what happened in Petrobras and was used by other companies and in other branches of the federal government. As I said, there are ongoing investigations not only in my court, but also in other federal courts that received parts of the case. Dozens of highly placed politicians, especially congressmen, are being investigated by the chief federal prosecutor before the Supreme Court. Some of them have been charged already, including the former Speaker of the House. All of these disturbing facts, especially cases already sentenced, allows us to conclude that an environment of systemic corruption was uncovered by the investigation. Corruption, as an isolated crime, exists all around the world. But systemic corruption, the payment of bribes as a rule of the game, isn't really that common, and it represents a severe degeneration of public and private custom, especially in democratic nations. The costs of the systemic corruption are enormous. First, the cost of the bribes that are usually added by the offending company to the contract in the public sector. Imagine that this is not an isolated practice, but a general rule, and you will understand how it can affect the management of public resources. Moreover, the need to generate funds for bribes in system corruption schemes can affect investment decisions by public and private entities. Perhaps some bad investments made by Petrobras can be explained not simply as a result of a bad judgment or unlucky choice, but instead as a deliberate choice by corrupted directors of Brazil's largest enterprise to generate bribes rather than take the best decision from an economic point of view. One example is the ongoing investigation about the purchase by Petrobras of an oil refinery here in Pasadena, Texas. One witness said that they deliberately intended to buy an old refinery because they were already thinking about bribes which would be paid in $1 billion contract to reform it. Some of them call, joking, the refinery as the red because of the time that passed and it was in a old stage, that refineries. Another detrimental effect of system corruption is that it chases away local and foreign investors. If the market is not clean and transparent, if bribes and cheating are the rule, a responsible investor will not have confidence in that market and you will not put its money in it. Above all, system corruption is damaging because it impacts confidence in the rule of law and in democracy. If the law does not apply to everyone, there is a progressive erosion of trust in democracy. Faced with a revelation of system corruption, what should be done? First, the judicial system must work. Crimes that are uncovered and proven, respecting due process, must be punished. Justice works when the innocent person goes home and the guilty person goes to prison. The outcome should not depend on the economic or political conditions of the defendant. There is still much to be done to advance in this respect in Brazil. Yet, the Lava Jato operation, just as other recent cases in Brazil, reveals that much can be done even under the current system, as long as the problem is confronted and treated with seriousness. Justice cannot be make-believe, with cases that never end and people who have been proven guilty of crimes who are never punished. The adequate functioning of the criminal justice system is a necessary, though not a sufficient, condition to eliminate system corruption. It's necessary that other public institutions, the executive and the legislative branches of government, adopt public policies aimed at preventing and combating of corruption. System corruption is not and cannot be a problem only for the judiciary branch. The government is the principal actor responsible for creating a political and economic environment free of system corruption. The government, with greater visibility and power, teaches by example. Better laws can be approved to improve the efficiency of the criminal justice system and to increase the transparency and predictability of relations between the public and private sectors, reducing incentives and opportunities for corrupt practice. Freedom of the press and access to information is also essential. The control of those who govern by the governed demands citizens that are well informed about the management of public life. Since the beginning of the investigation, it was our decision that we would not hide any information or evidence from the public. The Brazilian Constitution requires that the judicial process be open to public scrutiny. We cannot have cases prosecuted and tried in secret. Once the investigation was finished, everything, the prosecution, the evidence, the hearing of the witness, the judgment, and the sentence has been conducted under the light of the sun. In that regard, I take just this opportunity to speak here in Wilson Center to celebrate the memory of the Justice Louis Brandeis, who was elevated to the U.S. Supreme Court by President Woodrow Wilson 100 years ago. It was him who once said that, I'm quoting, "Sunlight is said to be the best of disinfectants." This is important to open the case to public scrutiny, not because we want to judge these cases in the realm of public opinion or to manipulate public opinion. It's important to prevent any attempt by powerful defendants to obstruct justice. In fighting system corruption, private sector initiative has also a relevant role. Corruption involves those who make illicit payments and those who receive them. Both parties are guilty. Companies must do their homework, saying no to the payment of bribe, implementing mechanisms of internal control, and denouncing requests or demands for payment of a bribe. It's also important to act collectively so that companies involving corrupt practice are identified and isolated from the market and not allowed to assume preeminent position. Much can be done, and it's important to keep in mind that system corruption is a product of institutional and cultural weakness. No country is predestined to live with system corruption, since it's not a natural phenomenon. Discovering and revealing it, even if it generates impacts in the short term, is not part of the problem. It's part of the cure. Once system corruption is discovered, necessary public policies should be adopted and implemented to overcome it. The problem cannot be resolved by sweeping it under the rug. Perhaps more than any other case in the past, because of the dimension of the crimes that have been uncovered, Lava Jato operations provide Brazil with the opportunity to take the necessary steps to overcome this shameful practice. It is too soon to say whether that will happen or whether corruption will be contained and reduced to more reasonable size in Brazil. It's difficult today to make predictions. There have been reactions to Lava Jato operation, of course. These have come especially from some of the companies involved and from politicians. Some critics have complained that Lava Jato operation is not impartial and has been used to play politics. That's not right. Of course, if the crime involves bribes paid to politicians, the case will inevitably have political consequences. But this happened outside the court, and the judge doesn't have control of it. Some critics say that Lava Jato operation represents the criminalization of politics. The blame should not, however, be aimed at the judicial process, but rather at the politicians who committed the crimes. The judicial process is just a consequence. The judiciary system could not and cannot turn a blind eye in the face of the crimes. Some critics say that due process is not being respected. I respectfully disagree. Every aspect of this judicial process is being conducted in open court with respect of the rights of the defendants and based in extensive evidence obtained, processed, and publicized under the law. Lava Jato is not a witch hunt. The problem is that the evidence of corruption revealed by the investigations was so widespread that the case took giant proportions, with numerous detentions and convictions. But nobody, let's be honest, is being charged or convicted based in political opinion. When there is evidence of illegal conduct, the accused are being charged and convicted not because of his opinion, but for the bribery and the money laundering crimes they committed. This is so much different. To summarize, reality has presented us in Brazil with an opportunity to face system corruption. I read sometimes in foreign newspaper statements of criticism against the system corruption uncovered in Brazil. The critics are correct. What has been exposed is shameful. But there is another way to look at this picture. The crimes are becoming known because of the efforts by many Brazilians to face and fight the problem. The police, the prosecutors, and the judiciary are serious dealing with it. It is, of course, an ongoing investigation, but some of the results of the cases already tried have no precedent in Brazil. We had several corruption scandals in our history, but never before Lava Jato, top executives of the country's biggest construction companies were arrested, tried, and convicted for bribery and money laundering. Never before Lava Jato had a director of Petrobras been charged of a crime. Today we have 4 of them convicted and serving prison terms. Several congressmen are being investigated and prosecuted before the Supreme Court. I believe this is progress in the implementation of the rule of law in our country. And it has had some beneficial collateral effects. In a possible collateral effect of the investigation of the Petrobras scandal, our Supreme Court overruled a past decision that postponed indefinitely the execution of a prison sentence, as I mentioned in the beginning. Now the Supreme Court understands that enforcement of a criminal conviction is permitted just after the sentence is affirmed by a court of appeal. So society no longer has to wait for a final decision at the highest level of appeal, which, as I said earlier, can take an eternity. Now, thanks to a new interpretation by our Supreme Court, a criminal conviction can be enforced immediately after it is affirmed by a court of appeals. This is a kind of a judicial revolution in the enforcement of criminal law in complex cases in Brazil. Our Supreme Court has clearly demonstrated with this new ruling that it fully understands the connection between system corruption and impunity. For this ruling, it deserves a lot of compliments and our collective gratitude. It's also true that until now, the police, prosecutors, and the judiciary have been the main protagonists in our nation's efforts against system corruption. So far, the government and the Congress have made no significant contribution in Brazil's efforts against corruption. For example, they could do so by proposing and approving better laws to prevent corruption. They could also help efforts of the law enforcement agents in other ways. Their omission is very disappointing. Just to be fair, the actual government said in several opportunities that it supports and endorses the investigation. But Brazilians should expect more than speech support. In spite of that, it's important to highlight that last year and this year, millions of Brazilians protested in the streets against corruption. On 13th of March of this year, more than 3 million people occupied the street in several state capitals and major cities of Brazil in peaceful demonstrations. It is true that these demonstrations were motivated by many causes, like satisfaction with the state of economy and with the former government. But it's also true that a common cause that united the demonstrators and the country was to rally in protests against systemic corruption and in support of Lava Jato operation. This attitude of our country's citizens gives us great hope. The fight against corruption has definitely entered in Brazil's public policy agenda and it will influence our political debates. This is very positive. Hopefully, some years from now, we will be able to look back and say that Lava Jato operation was part of the strengthening of the rule of law and democracy in Brazil. Maybe we will be able to say that systemic corruption was overcome and became a sad memory of the past. Obviously, we cannot take this for granted, but it's necessary to have some hope. I'm very confident that the Brazilian judiciary, prosecutors, police, and other law enforcement officials will keep on doing their job as far as they have public support. I thank you very much for your attention. I'll be glad to answer your questions.
Well, I would like to invite now Judge Peter Massetti to make his comments, and then we will open for questions. So get your questions ready.
Judge Moro, Ambassador Harrington, Paulo Sotero, my dear friend, ladies and gentlemen, it is an honor and pleasure to be with you this afternoon. Judge Moro, thank you for an excellent, informative presentation on Lava Jato and the whole concept of combating political corruption in Brazil. I want to offer some perspectives as an American judge. We have similarities with the Brazilian system. We have differences, and it perhaps is of note to listen to some of these. First, of course, in the United States, we have had our share of scandals. It is not just Brazil that we talk about. It goes back to Yazoo land scandal in the state of Georgia about the time of the establishment of the Republic, through Tammany Hall, Teapot Dome, Abscam, for those of you who remember the movie American Hustle. Abscam was what it was about. Jack Abramoff, not to mention Spiro Agnew. It goes on. And we've had our trials with regard to this kind of corruption as well. So we are all in some ways faced with similar problems. You'll note that most of our prosecutions for political corruption take place in federal court. I want to say a quick word about the federalism in Brazil. They were a colony for 300 years. They weren't 13 separate colonies, so issues of states' rights and state sovereignty really are not so present in Brazil. That's why most of the law in Brazil, everything that you hear about, not just bribery law, not just money laundering law, is national in scope. When you talk about the civil code and the criminal code and the procedural codes, those are all national laws, and they are applied both by federal and state court judges. Not so in the United States, where most of the day-to-day laws involving crimes and commercial and civil matters are defined by 50 different state laws. But in the United States, when it comes to bribery, when it comes to money laundering, those are federal statutes and they are prosecuted in federal courts. Now, we prosecute a lot of state officials in federal court. Why is that? Because the fact is, if you are prosecuting a state governor and it's a state judge who was appointed by the governor who's going to hear the case, that presents a difficulty. Now look at the case of Governor Robert McDonnell. Just was before the Supreme Court recently, the governor of Virginia. Several of you, I suspect, live in Virginia. The Supreme Court held unanimously, I might note, that he was not guilty of failing to render honest services, because all he did, despite the Rolex watches, despite the golf clubs, despite the loans to his wife, despite paying for his daughter's wedding, all he did was set up meetings for his constituent. Well, some of us have some problems with that issue, but that was not an official act, according to the Supreme Court, and therefore not the corruption. It remains to be seen where we stand under the federal statutes in the future, but that's our own recent experience with federal corruption. Now, I, like Judge Moro, am a federal district court judge. We are colleagues in that regard, and we do have a lot of things in common. I am a judge of first instance. I've tried a number of political corruption cases, nothing of the scale that he has tried, but sometimes 15, 20, 25 defendants, often in drug-related type cases. So that I have some experience in that. But you note he said he's been a judge for a long time, since he was a young man. We don't quite have that system in the United States. Being a judge is not a career option. You have to be nice to a lot of people along the way to get where you get, whether it's at the state level or the federal level. But he began as a career judge, and a very accomplished one, because he had to pass a rigorous exam and he had to be promoted along the way. But he's had a lot of experience for a young man. As the fact of the matter is, I went on the state bench at just about his age. You're about to be 44, if I'm not mistaken.
Yes.
Well, I was 44 when I was first appointed. So there you have the difference. In any event, as in Brazil, in the United States, we investigate our cases in the federal level, much as they do in Brazil. The federal police, which in many ways functions like our FBI, does a lot of the investigating. Turns over the evidence to the prosecutor's office, the U.S. Attorney's Office, which is comparable to the public ministry in Brazil. They develop the case, and then they will, in our case, often present it to a grand jury, which is not an institution that you have in Brazil, 23 citizens who decide whether or not there's probable cause to charge someone. And then they go ahead and they charge. And the judge, for the most part, is passive. But, as in Brazil, the judge does have an active role when it comes to certain decisions that are made before trial. It is required that the judge authorize searches and seizures except in limited circumstances. It's required that the judge authorize wiretaps, telephone taps. It's required that the judge authorize the breaking of bank secrecy and the access to bank records, and of course even access to the internet accounts, which you can do these days. You have to go to a judge first. You have to show probable cause, or in Brazil I think it would be called justa causa, to be able to do these things. You just can't say, Judge, let me do it. You can do it. There's got to be some indication that there's a basis for doing it, a colorable claim of illegality. So that is what we do, much as they do in Brazil. And of course, in the United States, in these cases, particularly political corruption cases, you can have a jury. Any crime that carries the possible sentence of more than 6 months, doesn't have to be homicide, can be tried before a jury in the United States. And many defendants in political corruption cases do opt for a trial. Now, it bears noting that the concept of the jury in homicide cases in Brazil is really a borrowing from the Anglo-American system. That it really goes back. It's one of the few civil law countries, Brazil, that has adopted the jury system in any respect, but they do have it in homicide cases with some variations that perhaps we can talk about on another time. I would say that we have much the same authority as Judge Moro does as federal district judges, but one of the things that's interesting in Brazil, which I've noted, is that when you're preparing a criminal case, if you are a defendant, you list who your witnesses are going to be in the case at the time that you respond. And then you can ask to be able to speak to those witnesses. And then again, you need the judge's approval to be able to speak to the witnesses. And if I'm not mistaken, Judge Moro, someone recently listed Dilma Rousseff as a witness, and you ordered that she appear and be available to be deposed. Am I correct?
We have a special rule that allows her to answer the question
By writing.
By writing.
But she can't refuse.
No.
You don't have to speak to a person. If you're in a criminal case, you have to go to the grand jury and you can be held in contempt if you don't answer. But if you're the witness in a case, you don't have to speak to the defense attorney. And in Brazil, you do have to speak. And you can do it perhaps if you're someone like the ex-president or the president in waiting, as Dilma is. You can do it perhaps by video or by written. But other people have to appear and give statements, which is a rather interesting approach to pursuing a criminal case. The concept of privileged forum has been mentioned. This is something that really is quite unfamiliar, I think, to the American audience. In the United States, if you are charged with a crime, doesn't matter who you are, you go to the trial court first, people like me. And then you may have a jury trial, and if you're convicted, you get an intermediate appeal. You may be heard by the Supreme Court. They have discretionary authority to review, so they may not want to hear you. But in Brazil, certain people, as Judge Moro mentioned, have a high level, the president, vice president, high members of Congress, have what's called the right to privileged forum. They get to have their case heard in the original instance by the Supreme Federal Tribunal, also called the Supreme Court. Now, our Supreme Court has no original criminal jurisdiction. They just don't. But in Brazil, there is original jurisdiction as to this category of person. And that is why some of the cases that Judge Moro is dealing with, some of the people are in the Supreme Federal Tribunal. Most of them are with him in Curitiba in the federal court. But he's got to juggle the fact that some people are involved and some are not. And then it gets complicated. For example, if you've got somebody who is in a conversation who's not the beneficiary of the privilege in conversation with somebody who is the beneficiary of the privilege, what do you do with that? Well, he's been up and back and forth to the Supreme Federal Tribunal many times. I think it's fair to say that although he's been up many times before the Supreme Federal Tribunal on his decisions, his record is pretty good. I think it's less than 4% of his decisions have been turned around. Pretty good, given the fact that he's handling a rather large transaction. So that's the federal concept of privileged forum. And it exists because the idea is that certain high-level people should really only be heard by the highest level people. Not that we feel inferior to Supreme Court justices, but that's the way the system works. So that they are, in Brazil, entitled to have their cases heard by the high court. I want to say something about plea bargaining, which is something that you've heard about. Now, this is really, in my view, one of the most remarkable things that is going on in Brazil today. It is not a concept that historically has had much presence in Brazil until recent years. It's being used with great effect in the Lava Jato case. Perhaps the single most important feature is plea bargaining. All right, for those of you who need quick refresher, plea bargaining occurs when a defendant is charged with a crime, and in order to cooperate with the government by turning state's evidence on his colleagues or doing something else, the prosecutor will say, okay, I'm not going to charge you with a crime, or I'm going to recommend a reduced crime from what you've done, and we'll do a deal, we'll do a bargain, we'll do a plea bargain. And then they reach an agreement in the federal courts in writing, goes to a federal judge who then endorses it and agrees with it. In Brazil, there is plea bargaining. They didn't have that, though, until recently. It started, for example, with minor crimes, transação penal, where basically people who were charged with crimes punishable by less than 2 years could work out their differences without an elaborate proceeding. And then serious kinds of crimes called crimes hediondos were also included. And now, more recently, financial crimes, and almost any kind of crime now, the judge has authority even to go to the point, depending on the seriousness of the circumstances, of giving a judicial pardon of the crimes. Now, this is an interesting concept. In Brazil, they have what's called a principle of obligation on the part of the prosecutor. The prosecutor has to prosecute all the crimes. The prosecutor can't, as in the United States, say, I think I won't charge this crime because I have absolute discretion. The judge can't do anything about that. Or maybe it may be a serious crime, but this person is such an important cooperator that we're going to let this person get us a real benefit. Take the example of the underboss of John Gotti, the Teflon Don, the mafioso of New York. 18 homicides. He was given 5 years for his plea bargain. Why? Because he turned state's evidence on 35 mafiosi. And because of his testimony, 35 not so nice actors went to jail. And that was a pact with the devil. But at least that's the way our prosecutors can deal with plea bargaining in the U.S. In Brazil, it usually is a little more limited than that. In most of the crimes, except serious other crimes, the judge is only authorized to give between 1/3 and 2/3 off the sentence. But in certain other kinds of crimes, the judge can go the whole way and give a judicial pardon. That's a very important aspect. Now, what's happened with plea bargaining in Brazil? Because of plea bargaining, they're getting a lot of these folks to turn around and say, okay, I'll tell you what happened. I'll tell you the deal that I made. And in the absence of that, it's difficult to make a case because, as the judge pointed out, often the only people who have the goods are the people who were involved in the deal in the first place. So that's a very important concept. And Judge, I'm going to ask you more about that tomorrow when we speak, because I really am quite fascinated as to how that works. Well, let me see. I have perhaps another comment or two. We also in the United States have pretrial detention, as they do in Brazil. It is the exception, not the rule. You don't automatically put people in jail, but if they present a risk of flight or a danger to the community, there is a basis to detain them, and we have used that. There's also another interesting concept about putting someone in jail following a conviction. In Brazil, until recently, you could not get a definitive jail term until the matter went all the way up to the end of the appeal system, which might have meant to the Supreme Federal Tribunal. Here, of course, it's always been the case, if you're convicted in the trial court by the judge, you go to jail immediately. Ask former Maryland Governor Marvin Mandel. He spent 19 months in jail, and then what? Reversed. Not guilty. Give me back my 19 months. Sorry, we don't do that. So in Brazil, they used to have this rule, but now, because it's got a real impact on enforcement, if a higher court, a second-level court says, we affirm what the trial court says, that person goes to jail, even though the possibility of appeal still exists. And by the way, another interesting point in Brazil, just cultural, the way to observe, statute of limitations. In this country, usually 5 years in federal court to file a criminal case. If you file within 5 years, you're good. In Brazil, whatever the limitations is, runs until you get the case fully heard in the appeals court. So it may take, if it takes you 10 years to get to the appeals court, you're not guilty regardless of what you did. Not a good situation. But that's why the premium for a lot of defense attorneys is what? Take it out as long as you can. You'll never be guilty. We'll talk about that, Judge Moro, sometime, about maybe some further improvement of the system in Brazil. But at least now in Brazil, there's an opportunity to incarcerate people before the matter goes to the highest court. A final word. You really have to appreciate the magnitude of what Judge Moro has done here. He's handling literally hundreds of cases. He's put hundreds of defendants. I don't know how many wiretaps he's authorized and how many searches and seizures he's authorized, but I mean the numbers in the multiples. No federal judge in the United States has ever seen anything like that. That's what's so remarkable about what he's doing. And he's doing really one significant job in doing so. I have had perhaps, as I said, 15, 20, 25 defendants. It pales by comparison with what he's doing. He really has done not only a signal job in terms of handling a very difficult case, but he's really inspired the Brazilian people that justice does have a possibility, that the long, dark night of impunity may be at an end in Brazil. It's very impressive as to what he's done. And as I've said on more than one occasion, it is very much my view that despite the travail in the executive and legislative branches in Brazil these days, the judiciary is shining. The public ministry is shining. They are doing what they're supposed to do. They are strong, they are independent, they are acting according to the Constitution, and it is my view, and Ambassador Harrington said it as well, what's happening in Brazil today is very likely to be a model of what's going to be happening in other countries that face the really debilitating effect of political corruption. With that, I thank you for your time.
Well, Judge Moro has agreed to answer questions. I ask that you raise your hand, wait for the microphone that will come to you. You identify yourselves and ask your questions in the form of a question. It's a very good way. Journalists know that. And just to start us, we have a group of journalists here, my old profession, my forever profession. I will come to you, but I will alternate. And Julia, we'll have Juliano Basile from Valor Econômico as first.
Do I need a microphone here?
No, you have one.
Oh, yeah? This
You
one?
have one there.
Okay.
Yes.
Hi, Moro. It's a pleasure to be here making questions for you. How long do you think that you are going to stay with the Lava Jato case? And also, why is so important to you to reveal the investigation to the press and also to the general public? I mean, your decisions that you are constantly revealed to the press.
Thank you for the questions, Mr. Basile.
Can you hear?
Do you hear?
Here.
No?
No, in the back. Yeah, go ahead.
No?
No, he's
Mike?
saying. You don't hear?
Now,
Do you?
Maybe I should speak loud.
sound okay now, I think.
Okay.
Well, first of all, let me say something about what you said. Thank you for your gentle comments. I must say that I learned a lot with U.S. experience in dealing with these criminal cases. I have the custom to read U.S. books about true crimes. For example, one that you said about the John Gotti case. That guy, Sami Bulgravano, I remember his name, a very bad guy, but he was important to reach the result that the prosecutors wanted. So I'm also very impressive of the U.S. experience in fighting crimes, not only political crimes, but you have a lot of impressive cases against the mafia, against drug lords. I learned a lot with your experience also. It's also true that I learned about plea agreements with a previous case I had in my hands. It was called the Banestado case. It's a long story, but we have some international cooperation from the district attorney of Manhattan in that case, because we need bank records in New York banks. And I remember that I met assistant district attorney of Manhattan, a great guy named Adam Kaufman. And once in an informal conversation, I asked him where I can learn more about the plea agreements. And he gave to me a paper written by a federal judge of United States. He was a judge of the 9th Appeal Court in California, and Stephen Trott. And a very, very nice work. I learned a lot with that text. So we are continuous learning with the experience of other countries. It's necessary to say that, in especially US. I have a great admiration of criminal law, especially the procedural criminal law here in US. Of course, as in Brazil, it have probably its problems, but well, we have to share the good experience of each country. About the questions, how long it will take? I can't say for sure because it's an ongoing case. sometimes new evidence appears, and as I said, we cannot turn a blind eye to this new evidence. However, thinking about the part of the investigation that is with us in Brazil, one day I said that it could end in the end of the year, because speaking about especially the enterprises who paid bribes, the great part of them, the most part of them, have been already charged and tried. But for example, the part that is with our Supreme Court involving the politician, it will probably take more time because of the heavy caseload the Supreme Court have. The judicial process is slow there. For example, in that case of Mensalão case, it took 6 years since the Supreme Court received the charges and judged the case. So my part may be in the end of year, but I can't say for sure.
Can the Supreme Court accelerate cases rather than just take them in order?
Yes, I think especially the justice who is with this case in the Supreme Court, Teresa Vasque, I think he is doing a great job. But the problem is that the heavy caseload, sometimes I think it's impossible to deal with these complex cases in a reasonable period of time. I think this privilege to have a special forum is something that's not working in Brazil. Maybe when they thought about it, they figured that they would have 1, 2, 3 politicians being charged. But now they have dozens. And well, the Supreme Court have to decide constitutional cases that are very important to the population. So how you can deal with these 2 issues at the same time? So some people say that it's necessary to change, and I agree. Maybe you have to limit more this privilege. And that's not only my word. Several people say that, even some justices of the Supreme Court. Like, for example, Justice Luis Roberto Barroso is saying that we have to limit this privilege because the Supreme Court cannot handle.
Or because some people think it's anti-democratic.
Yeah.
Everybody should be treated equally.
Well, I have people also, we have as many people in another room. I have questions from them, so I'll go there first, then I'll come back here. And a couple of questions from there, they are on the of the type journalists love, but I think it's not asked by a journalist. It is, the premise of these questions is that you, Judge Moro, may have avoided prosecuting people of interest associated with PSDB and allies. I don't know if the premise of the question is correct or not, but that's what the question wrote here. And if that is so, why is that? So, and the other question, which is a case in which obviously we know that you are involved, if you could talk about due process and original jurisdiction, about the audios, the leaked audios involving President Dilma Rousseff, was due process followed in that case? So those questions from the overflow room.
Okay, a lot of questions. Just me first finish question about why we put all the case in public.
Yeah.
I already said in my presentation, I think the public opinion in this case is involving powerful enterprises and powerful politicians is important to prevent any kind of justice obstruction, just that. And so, in truth, our federal constitution says that the case should be tried in public, in an open court. So we are just following the constitution. Unfortunately, sometimes even the constitution says that, and it's not, the cases are not treated in public. So I think it's an obligation, and in this case, it's very important to prevent any kind of obstruction of justice. Okay, and about the question of the other party. Well, I said in my presentation, if you commit a crime, the law have consequence for those who commit a crime. So it doesn't matter if you are from the left or you're from the right or you're from the center. For a judge, it's just a matter of law. So you could be from the left, you could be from the right, could be from the center, but if you commit a crime, you have to answer for your conduct. That's simple like that. Of course, in this case, because we're talking about Petrobras, a federal company, and saying about the cases already judged, it seems that the Petrobras was used for a political purpose, for example, a political party nominates a director of Petrobras, and the director take bribes for himself and take bribes for the political party. So it's natural in this situation that the politicians who appears in the investigations are those who belong to the political party that rule the state company. And in that case, for example, the Works Party is in the power since 2002. So it appears that some politicians but not only from the Works Party, there are politicians answering investigations and charges from other political parties in the Supreme Court. I tried 3 cases involving former federal legislators. One was from the Works Party, 2 were from the Works Party. One was from the Popular Party, and the third was from the Solidarity Party, a small party in Brazil. So that's what happened. And about this other party that was said here, there's no evidence that these directors since 2002 gave money to this party in special, because this party was in the opposition. It would not make sense. But, well, the problem is that always in these cases that involve politicians, sometimes the politicians strike back saying, you're playing politics. Oh, the problem is the crime, the evidence.
On the audios, the leaked audios of President Dilma Rousseff, would like to say something?
Oh, this is a little bit complicated because this is a pending case. Okay. So I talked about the case I already tried, and this is easier. So I won't say nothing Just that I already sent information to the Supreme Court about it.
Okay, thank you. Question there in the middle, Julia, the lady. Yes. No, there. Yes, you. You. Identify yourself.
Hi, my name is Mayra Bezerra, and I'm from the University of Maryland, College Park. And I am a Brazilian citizen, and I think my question is more related as a citizen from Brazil. So I would like to know, you provided some examples saying that there is a huge problem with the huge load of work that the federal court has. So I would like to know if there is any movement or discussion about some solutions to resolve that issue, in order for the citizens to know if we see a light in the tunnel for the future. And also if there is any discussion about to reduce the privilege of a few in Brazil, and if we could foresee a brighter future as about equal judgment system for everybody in the country.
Yeah, I would add a question from a person in the other room. How foro privilegiado affects, the work of a judge, or especially in Lava Jato? How does it affect? How does it affect?
I think about the second question, we already answered it during the presentation and the previous answers. About your question, as I said in my presentation, I think this is a long process. There is no magic solution for this problem. You have to take measures day by day. Okay. So far, the Congress did not take any serious step in approving laws or discussing laws that could prevent this kind of cases. But I think we should have hope in the future and demand from our congressmen that they should act, they should do something. We cannot just return to the past. We have to move on.
But of course, the congressmen are the people who are the beneficiaries of protection, so it's not likely that they will vote themselves out. It's like if you could say to every minister, if you could do away with evil, would you do that? And they say, no, we'd lose our jobs.
Well, let me now ask one question that comes from actually a former student of mine, Lindsay Arieta. She's now an attorney here in Washington. Two questions actually. What legal reasoning or standard allowed for bank secrecy to be suspended? Has bank secrecy been lifted in previous white-collar cases in Brazil? And second, has the recent reorganization of the federal government affected civil administrative cases related to Lava Jato?
The last question? What?
Has the recent reorganization of the federal government, means I think the evolution
Temer.
from
Okay.
Temer, affected civil administrative cases related to Lava Jato?
Okay, about the lifting of bank secrecy, it's, I think, a little bit similar of US. You need to have some, as Judge Massett said, justa causa, the word you use in Brazil.
Probable cause.
Here you use probable cause. I understand that here in US you use the grand jury to lift the bank secrecy. In Brazil, we don't have grand jury. We have had it in the beginning of the Brazilian Empire in the 1832. The first criminal procedure code, we have grand jury and petit jury. In Brazil, the model was from England, probably, but not far from that. They cut the grand jury. Okay, but in Brazil, the judge has to have some evidence of criminal conduct to lift bank secrets. And it happens not just in this case, but in several cases of the past and a lot of other cases. What is more difficult nowadays is that usually in complex cases, criminals use accounts abroad, offshore accounts in other jurisdictions, or even in accounts in Brazil, they use front companies, straw man. So this strategy of follow the money sometimes is very complicated. But for a legal point of view, the Brazilian judge could lift the bank secrecy if there is probable cause, okay, under a request from the prosecutors or from the police. About the reorganization, I think it's too soon to say that because they are in charge in about 2 months. As to be fair, as I said in my presentation, the new president said in several speeches that that he support and his government support the Lava Jato investigation. The Ministry of Justice also said that. But as I said in my presentation, I think it's necessary more than that. But let's be fair, the government started only 2 months ago.
And pretty busy.
And pretty busy. But I have hope that the new government will support not only the investigation, but try to reform the systems. Of course, it's necessary that every Brazilian citizen demands that from its government. But we cannot lose our faith in the future.
Okay, thank you very much, Marcelo Ninho from Folha de São Paulo.
Obrigado, Paulo. Judge Moro, you mentioned in your lecture that there was one of the big victories in the criminal system was a recent decision, a recent ruling by the Supreme Court in Brazil allowing the prison of people who were already sentenced before the final decision by the highest court. But after that, there was a decision by a justice, Sérgio de Melo, allowing a convicted criminal in Minas Gerais, saying that the prison should wait for the final decision. So I wanted to ask you, you think this is, you comment this decision by Justice Sérgio de Melo, and tell us if you think this could be a problem for Lava Jato? And just if I could squeeze just one more question. Recently there was an intellectual from the left in Brazil, a very well-known one, said that you were trained by the FBI to do the Lava Jato. So if you could comment that also. Thank you.
It's not exactly the FBI, but okay. Let's take that.
About the judicial opinion of Justice Sérgio de Melo, I can't say too much because I cannot comment the decision of higher justice. I respect a lot Justice Sérgio de Melo, but he was in the minority of that decision, that past decision of the Supreme Court. So I'm not sure if this means that the Supreme Court will change his previous position, because there were the majority and there were the minority of the judges. Maybe there's always a possibility. Nobody can predict it, what the Supreme Court in Brazil or in US will decide. But it's a very recent decision. I think it will be difficult to have changing in the decision if there is if there is not any change in the composition of the Supreme Court. That's my opinion. Okay.
Okay, let's go to the back here, the lady in red.
Second part.
Oh,
the
second part. I'm sorry. Go. Second part.
We're back in the Cold War, maybe here. I don't have any comment about that.
Okay. Yes, the lady there. Then yes, go.
Thank you. Good afternoon. I'm Fabiola Ortiz. I'm a Luso-Brazilian journalist. I write for Luz, a news agency for Portugal. If you could speak on a little bit more on international collaboration, and especially with the Portuguese authorities. Has Portugal been collaborating with you, and in which ways? And very recently, a Brazilian citizen living abroad in Portugal was extraditado. Are there many Brazilians involved that are overseas and should be extraditado, please? Thank you.
Well, and I will add one question from the other room that wanted to ask more about if you could talk about the nature of cooperation with foreign governments, especially with Switzerland, in relation to the bank accounts held by defendants in Switzerland. So Portugal and Switzerland.
Okay. Not only for Brazil, but for any country, international cooperation nowadays is sometimes the key in these complex cases, because especially in money laundering, the criminal put his money abroad, and sometimes in a more classical movement, he also flee abroad. The prosecutors and the police are especially in charge with this contact of the international authorities. So sometimes they have a better knowledge of this interaction with their counterparts in the other countries. About Portugal, I saw this recent decision of, and it was very good for Brazil, that they decide to extradite that Brazilian who have been naturalized in Portugal, but after the crime. So they, I think they understand that that he was trying to evade Brazil jurisdiction, extradition with this act. So they decide to extradite him. That was very positive, because when a country don't cooperate with another, who wins is the criminal, not the country that not cooperate. So I'm happy to say that we have some cases involving international cooperation with U.S. usually help Brazil. I think you receive more requests than we receive requests from you, and it was especially important that MLOT treaty that Brazil signed with U.S. during your work as ambassador in Brazil. I compliment you for that.
Thank you.
Thank you very much. And with Switzerland, it's the same. Probably some of these criminals thought that Switzerland was still impenetrable heaven from criminals, and they are showing that that's not true. They cooperate. So we have a lot of evidence in these cases came from Switzerland, especially fortunes kept in offshore accounts by Petrobras director, for example.
Okay, and about Portugal, I cannot resist. Congratulations. Parabéns. It was wonderful. Cláudia Trevisan, from o estado de São Paulo, who also is one of the many Paranaenses in this room.
There are at least two big projects to fight corruption in Congress. And actually, how optimistic you are about its approval, and if you think the change in the Speaker of the House and the election of the new Speaker of the House will help in the vote of this project. And also, how do you see attempts like the ones from Renan Calheiros to try to either change the plea bargain institution or now it's disoffensive to approve this abuso de autoridade project?
I don't know if you could hear that. Could you hear it?
Yeah. I don't.
If you could repeat it, because I think a lot of people did not hear her behind.
Paolo,
Yes.
you want to?
Maybe, Paulo, can you repeat the question?
The question was about proposals in Congress that could somehow get in the way of Lava Jato operation.
The plea bargaining.
Especially, plea bargain, limiting plea bargain, and some of those have been pushed and advanced by the current president of the Brazilian Senate, Mr. Renan Calheiros, from the state of Alagoas. And
Also
and
the change of the Speaker of the House.
the change of the Speaker of the House, if there is anything.
I cannot say about the change of the Speaker of the House because I think it's a political issue. I don't think it would be appropriate. About these bills of law, I think in the end the Congress will make the right decision to disapprove bills of law that try to obstruct the work of justice, not only in this case, because a law have general effects, not only for Lava Jato, and I have hope that they will deliberate about the bills that were presented to Congress by the Ministério Público initiative of the 10 bills against corruption. I hope this, because of Lava Jato, for example, a federal congressman present a bill that he wants to prohibit a defendant who is in prison to make a plea agreement. It does not make much sense because, well, it's not only the problem that this could obstruct a plea agreement that could be important, for example, that case of Samibu Gravana, but there is a limitation of the defense, for the defense, because to defense, make a plea agreement, it's a way of defense. So I don't think it will be approved. And about that bill reforming our law about abuses of authorities, I think there is the original proposition does not pretend to obstruct Lava Jato investigation, but in these times the approval of this law would be very disappointed, and especially because some of part of the tests could be read as a threat to the judicial independence. Of course, nobody wants abuse of authorities, but you could not punish a judge to apply the law with independence. He have to have independence to make the best interpretation of the law that he could do. So I have hope in the Congress that they will not take these steps. Of course, as I said earlier, it's necessary that the Brazilian citizens demand the Congress to do the right thing.
Okay, I want a non-journalist asking a question now. Yes, okay, you're not a journalist yet.
My name is Eduardo. Thank you, Paulo. Congratulations for all your accomplishments, Judge Sérgio Moro. And I would like to ask you to elaborate a little bit more in the plea bargaining agreement and also the flip side of it. And also, how can the Brazilian people can be sure that this instrument is really being effective in order to churn in the money that the people stole from the country? Because personally, I'm really skeptical about that. It's really effective in order to make those guys to bring all the money. So what are the instruments you are using that you believe that it's really effective in order for the Brazilian people to feel confident about that? Thank you.
One of the things that I read in that text of Judge Stephen Trott, he said he defends the plea agreements, but he said never trust in a criminal. That's the police and the prosecutors use the criminals in these plea agreements against their accomplice. Okay, but of course, everything that he says, you have to have additional evidence, corroborative evidence. Corroborative?
Mm-hmm.
Not
Yeah,
sure.
corroborative, yeah.
Corroborative.
And for him, if he lies, and if he said, for example, I have this $100 million in offshore accounts that I will return, but that's all. And the police or the prosecutors discover later that he has more money, he will lose the plea agreement. And then he already confessed he's guilty. And well, he will suffer the consequences of his lies. You cannot say for sure that they don't have more money, but they are putting they put their plea agreements and the benefits that they received in risk if they lie. Okay, and the police and the prosecutors keep on their investigation. They don't need to stop just because that criminal made the plea agreement. Okay, so for example, there are a lot of international requests still going on in Switzerland, and it appears another account of one of these individuals. They will suffer the consequences.
And let me add, when you are talking about the spouses, you also look to see that the money that the spouse has, that there's a way to park it happens in our system all the time. Money gets parked somewhere, not in the name of the defendant, but in the name of a spouse, a mother, a company, and you need to be very vigilant. And I think that's what's happening in Brazil now too.
You don't have a word, straw man, no?
Well, straw people, right? Straw accounts. You got to be very vigilant, and Brazil is, I think, doing that.
For example, that case that about John Gotti, that guy Sami Bogravano was prosecuted again later because he was involved again in illicit.
He was selling ecstasy.
Yeah, and then he got jail.
Right. Judge Moro, I have two questions here. One person is a Cristina and a Christine, and one is a Brazilian citizen, the other is an American student. And one is worried about, talks about the pressures coming from critics of your work and how do you remain committed to your work despite those pressures. Second, and it's a question that many of us think about, in terms, do you feel safe? Do you feel protected? And I think it's a relevant question, so we would like to hear.
Well, let me say, I so far I could do my work without any kind of direct threat to interfere my work. And it's important to say that sometimes they think they overestimate my job because I'm a judge in the first instance, but the case depends on the job of the judges of the other levels of the judiciary. So it's not a one-man job. And there are the prosecutors, there are the police. As I said in the beginning, I'm not an investigating judge. So sometimes they said about the Judge Moro strategy of investigation. And I said, no, I don't have none because I only decide over the requests of the prosecutors and the police.
But you can call witnesses during a trial.
Yeah,
At your own decision. As, by the way, an American judge could do the same. You can call a witness in a civil or criminal case. What you can't do is supply a missing element for the prosecutor. That would be tilting in favor of the prosecution. But for example, where a defendant's rights are not being protected, you could call a witness to help exonerate. And Brazil has the same. The Brazilian judge has the same authority.
Yes, that's true. But usually the judge plays a passive role.
A passive.
Despite his have these powers to do something else. Well, what is very complicated sometimes is political criticals. Sometimes, and as I said earlier, if a politician commit a crime, he must answer for his conduct. I don't care if he's from the right, from the left, from the center. That's could not count in the application of the law. Just that. And about the safety, there is a rule that you never talk about your security procedures. So I can't say nothing about that.
Okay, I will never ask it again. Let me ask it for both judges here. It's a very interesting question about the person noticed that the Lava Jato investigations has led to initiation of various proceedings in various different courts, entities, CGU, TCU, CADI. There are things, multiple actions, and it's basically about double jeopardy issues. Is there, do you foresee, I don't know, a scenario in which double jeopardy as it is understood in the United States would interfere negatively in proceedings involving Lava Jato crimes, either in Brazil or here or somewhere else?
Are you asking me first?
Yeah, well, the two judges.
Let me say something about that. These entities are administrative.
Okay.
So if CADE or TCU decides something about this case, they usually impose administrative sanctions like fines. They don't judge criminal conducts. So, of course, there is a chance that some of these people or enterprise could be responsibilized by the criminal court, by the administrative organs or courts, but not for the same criminal conduct. So I think there is no risk of double jeopardy.
Okay.
You want me to respond?
Yes, sir.
And I think likewise in the United States, unless it's in a court any administrative sanction will not preclude double jeopardy. IRS may impose penalties for non-payment of taxes. You can still be convicted of income tax evasion. So there is that possibility. And as between Brazil and the United States, if you violate the law in Brazil, money laundering, it's a separate law in the United States. You could be prosecuted under the laws, let's say, of the state of New York or the U.S. courts for a separate crime. So it doesn't really preclude, one doesn't preclude the other.
Thank you very much.
That is a problem to those who commit crimes, transnational crimes, because they can suffer judgment from both countries sometimes. If you launder money here in U.S., you may have problems.
Henrique Batista from Jornal O Globo.
Hi, Judge. What is the biggest challenge in the last few months for Lava Jato, and what you planning do after your participation in Lava Jato? Thank you.
Vacation.
Disney World. Come to Disney World.
I'm not so sure that there are less few months of Lava Jato. Maybe that's a possibility. Well, after the works finish, I'll take, as suggested, long vacations. I think I deserve it. Just that. Then I'll return to my job as a judge. I'm a professional career judge, and that's what I am.
Okay, Ligia. Here. Julia, give it to Ligia, right in the middle. Back to the journalists. They are monopolizing it now.
Thank you, Ligia Hoagland from Radio France International. Do you think it would be beneficial to have a more flexible probatory standard in the case of complex crimes in Brazil?
In which way? Could you
So
explain
that
more?
would be easier to punish cases of money laundering or corruption against the financial system in Brazil. That wouldn't be so hard
If what?
to send the guilty parties to jail.
That you're saying that it's too hard now in Brazil? No?
Isn't there too many recourses that people can take,
Yeah, the context is this. There was a major crisis here, 2008. Many things went wrong, and there were there's even a movie that won the Oscar, a documentary about this. Not a single person went to jail, or there's actually one person went to jail because financial crimes or alleged financial crimes in the United States, fees were paid, companies paid enormous fees, right? So it's a matter of debate in the United States. It's a matter of source of criticism. And the question, I think, relates to that,
yes.
right? And
I'm sorry, I did
But I
not
think in one
understand.
of your books you even talk about that, right? The probatory standard?
A purgatory standard?
Probatory standard.
Probatorio. Okay. Well, it's very difficult to me to give an opinion about the U.S. system.
No, about
No?
in Brazil.
Brazil?
It should be more flexible.
More flexible? I'm not sure. I don't think so because what I talked in my presentation was about system corruption. So sometimes they said, oh, Judge Moro is too hard, too harsh. Well, we have a big problem here. System corruption damages economy, damages democracy. And I think facing that problem, you have to take some hard medicine. And of course, for example, pretrial detention is an exception. But in a context like that, sometimes you have to be more hard to show that you are talking serious. I was reading these days a book written by José Elgas, who is the actual president of International Transparency, and he he tell in that book the story of the criminal procedure against Fujimori Montesinos in Peru. And well, it's an impressive story, fantastic story. And he says in the book similar things. When you reach that situation, I'm not sure if Peru was better or worse than Brazil, but when you face a problem in this dimension, you have to take hard measures or you will go nowhere. That's my opinion.
There's a question here addressed to both judges, but it's in a sort of a one-sided way. I'll make it to go both ways, which is, in your opinion, how could the U.S. help Brazil to have a more efficient and fast prosecution process, especially related to government officials? And I would like to ask Judge Massetti, who has studied this, if there is anything in the Brazilian process that would serve as inspiration for American law enforcement and judges.
Well, I think the only way, obviously, that you can influence what happens in one country, if you're from another country, is to talk about your experience, share your experience with people in the other country, and they may find some wisdom in what you have to say. Over the years, and Paulo knows this well, we had discussions about the concept of implementing precedent in the Supreme Federal Tribunal of Brazil, what in Brazil they call general repercussion, or repercussão geral, before they would accept the review of cases in the High Court. And then the concept of, that was first of all discretionary review, and then the concept of precedent, whether decisions once made by the court should be binding. A lot of that came from dialogue that started many years ago with people like Carlos Veloso, who was in the Supreme Federal Tribunal, Ellen Gracie Northfleet, and so on. And we were all part of that dialogue. That's a good example of how dialogue can help. As far as in future, I mean, there's a lot more to talk about. Many of the same kind of experiences that we've had, we can talk through our experience and show what's good and bad in our experience and offer it with to the Brazilians. And certainly it works the other way. There are aspects of the Brazilian system that might well be useful to our system. I mean, I haven't really gotten into that issue so much now, but the whole issue really is one of dialogue and a two-way dialogue. And I think that's the way one country successfully influences another. I think you would agree. And you heard Judge Moro say, I studied a lot of things that happened in the United States. And I think you were telling me earlier, in Italy, you studied what was going on in Italy and other places.
Yes, yeah, we always learn about this foreign experience. In the judicial process, as far as I know, I don't think Brazil have problems with international cooperation with U.S. And I hope that U.S. don't have big problems in international cooperation with Brazil. But this sharing of experience is very important. To both countries. Both countries could learn with each other. And so, congratulate for this kind of...
Actually, let me give one quick example, not from the criminal context, but the civil. There's a new code of civil procedure in Brazil, and one aspect of it is that there must be mandatory conciliation before the case can go forward, and that states are urged to set up mediation centers to deal with these cases. We don't have that in the United States. It's really pretty much optional at this point, but in Brazil, it must be done. There's a good example, in my opinion, of borrowing from Brazil that would be very positive for the American experience. Again, it's dialogue.
Paulo, it occurs to me that as we go down the road on the rule of law series, we might also want to focus on the prosecutorial and law enforcement aspects, what's learned and what could be contributed from the experience of each country.
I remember an example about this decision of our Supreme Court that after the confirmation by appeal court of criminal conviction, you could enforce it immediately. For example, some people in Brazil says that it's against the presumption of innocence. Well, then we take the example of U.S. and say, no, in U.S. after the criminal conviction of the trial court, you can enforce. So you don't have a presumption of innocence.
That's the argument.
In U.S. But we can't go to other countries also, because the same happens to France. France, after a criminal conviction of what they call the Cour d'Assises, the trial court of the first instance, they can enforce the conviction. So sometimes if you look abroad, out of your country, you can take arguments to rebuttal this kind of crazy affirmation. Because if the presumption of innocence demands that you need the final decision on the final appeal, in what in practice could take 10 or 20 years in Brazil, if presumption of innocence demands that, so you don't have it in the US and you don't have it in France. And that are the countries that presumption of innocence was born, if I'm not wrong.
Well, you get your first opportunity, and you're not presumed innocent once you're found guilty, and you have to run the risk of the appeal. That's the attitude. But you're right. Theoretically speaking, until the final word is spoken, you're not guilty, even though you're convicted in the first instance.
Okay, Cássia Carvalho from the Brazil-U.S. Business Council here in Washington.
Thank you, Judge Moro. Thank you for all the work that you're doing for Brazilian society. It's making a huge difference, and I want to thank you for that. So my first question is, you talked about Brazilian population putting more pressure on Brazilian government for change. How can you see civil society organizations such as Transparency International, but other ones as well, Brazilian ones as well, demanding better governance in Brazil, and the population in general demanding more better governance that would be effective? I mean, it was effective, the protests we had in March and previously. Should that continue, or are there other ways? And my second question is, what I really want to know, with over 50% of Brazilian Congress under investigation for one reason or another, would you consider running for public office, public life in the future?
Oops.
No, I'm running for vacation only. No, about your first question, I think there is a lot of ways that you can pressure Congress, the government, to do the right thing. You could go to streets. You could have organizations in civil society that demands, that present demands to the Congress or to the government. As I said in my presentation, I think the private sector have a huge importance in this, because if nobody wants to pay bribes, the problem is solved. Of course, this is a topic, but it's not a topic to think that widespread corruption could be terminated in Brazil. So I have some hope that, for example, some of these enterprises who were involved in these criminal cases will act different in the future, because they now know the price of the criminal conduct. And if you broke that system of corruption, maybe you could have the support of these private entities to reduce the problem. So there is no magic a decision that can solve all the problems. There is not a only way to fight this problem. I think you could do a lot of things. That initiative of Ministério Público to present bills, I think it was very important because it could mobilize public opinion in favor of really fighting corruption, not only in this case of Petrobras scandal, but others.
Ambassador Harrington.
I'd be interested to know, in the U.S. we have the American Law Institute, as it's called, and then the American Bar Association, the organized associations of the legal community, sometimes significantly involved in law reform and urging measures, proposing measures. Is there anything, where's the Brazilian bar on these issues, or are they focused more on liking the long judicial process that they enjoy now?
Well, that's a good question, a complicated one, because our bar, we call OAB, have a great history in Brazil. It fought the military government. It demands democracy, the democratization. And nowadays they have that public speech that they are against systemic corruption. They demand, for example, that some politicians involved in serious accusations of committing crimes should be expelled from office. But what is, I don't agree with this. They, for example, are against this decision of the Supreme Court, this recent decision that changed Brazilian law.
Yep.
So sometimes it seems everybody is against corruption, since this never changed. So you have to take some measures to solve the problem. And I can make these critics against OAB. I respect a lot our bar. And as I said, they have public speech that support the investigation. But in this issue, I think they are really wrong. This change was very important to fight this systemic corruption.
Just a quick supplement. Our Bar Association may be a little more neutral, but there are institutions in Brazil which do look at judicial legal reform. In the Ministry of Justice, there actually is a secretary for judicial reform. We have nothing like that in the U.S. Department of Justice. There's a National Council of Justice in Brazil, which also considers judicial and legal reform issues. We don't have anything like that in the United States. The American Law Institute is a group, and I happen to be a member, of a lot of semi-intelligent people, I'm among them, who come up with ideas about how the law can be improved. But actually, these are institutional, semi-governmental or governmental organizations that think about judicial and legal reform all the time. So just to look at the Association of Lawyers is really only one piece of the picture as to what's going on. There are organizations which are always talking about these judicial reform initiatives in Brazil.
So we are wrapping this up now. Any questions, urgent questions there? I'll collect a few there.
IDB.
Yes.
Cecilio Benz is IDB. We had a ceremony a few days ago because 5 police officers were victims. 2 presidents in this country were present to this ceremony.
Dallas. Okay.
And I see the paper that in Rio, so far, 57 police officers have been killed. What the judicial power can do to improve the situation, to give the police, that's very important, in the criminal cases, more safety.
Okay. Thank you, Bernadette. Yes.
Bernadette Buxbaum. I am an attorney here in the District of Columbia and also in Brazil. I have a quick question regarding these proceedings or this civil lawsuit that is going on in New York against Petrobras and that has 193 complainants. Which effect it will have? Its judgment is estimated to be in the end of September. Which effect it will have in the criminal cases in Brazil, since it will affect economically Petrobras?
Okay, and one final one back there.
At the beginning of your talk, you said there was a difference between the Portuguese word, which I won't try and pronounce, and the English word car wash, and one of them had a double meaning.
yeah.
And you said you'd explain that.
Oh.
You caught me. Okay. I was not expecting that question. Okay, the first was what?
That was about dollars and
Dollars. Yes.
killed.
Well, the Brazil have a lot of problems, not only corruption. This is very complicated problem because there is violence from the police. There is violence against the police, and Rio de Janeiro have serious problem with that. I understand that in the later years they made progress in this area in Rio de Janeiro. They have some areas that only that were ruled by drug lords, and I think the police and the Rio de Janeiro government reduce the problem, but the numbers are still very disturbing. There's no easy answer for this question, but as I said, corruption is not the only problem of Brazil, but I think that maybe if you have less corruption, you could deal better with these other problems, and you could face them both at the same time. But I don't have an easy answer for your question. That's a very serious problem in Brazil, the crime rates, and not only corruption, but violent crimes. The other question about the Petrobras case here, well, I don't have much knowledge about that case, only what I read in the newspapers. I don't think the judgment of the case in U.S. will affect our cases. Probably, maybe it could affect Petrobras, but that's something that we don't have, I don't have, and we in Brazil, the prosecutors, the police, don't have any control of it. So let's see what the judge will decide in that case. What is important to say, I think, that Petrobras is a state-owned company, so I'm treating it in my case as a victim of these crimes, because at the end of the day, who will pay for the damages is the Brazilian people. But I'm not sure how this affects the judgment here in U.S.
Do you want to say something about o duplo sentido?
Oh yes, the double meaning. No, this is very simple. One of the individuals who were being investigated in the beginning, he was owner of a gas station in Brasilia, and he used that gas station to money launder. Not just bribes, but drug money also. I can say because I tried his case. He was convicted of money laundering, bribe money, and drug money also. And in his gas station, he had a car wash. And then the case was nominated in the beginning Lava Jato because of this car wash in that gas station where the investigation started. And also Lava Jato have the meaning of, it could mean that you are money laundering quickly. Okay, so this double meaning because of the car wash, and it's a reference to the gas station where the investigation started, and also to the fact that these people launder the money very quickly. They are very professionals in what they did. So that's the double meaning.
That's an import from the United States. Fast wash, like fast food. Everything is
Yeah.
Now,
Fast money laundering.
fast money laundering. Well, I think if would you have? There's one of my friends and a friend of Ambassador reminded us of something that I remember very well. It's a friend of mine, ours, Ambassador Melvin Levitsky, Ambassador U.S. to Brazil in the 90s, before President Clinton came for a visit. Gave an interview where he said something that was pretty obvious to most journalists in Brazil. I did not report on that because I knew it, but he was quoted as saying that Brazil had endemic corruption. And I looked at that and said, yes, we do. So I'm not reporting it just because an American said it. We already know it. So, but on a slow news day on a Sunday, a dear friend of mine wrote in O Globo that the American ambassador had accused Brazil of having endemic corruption. And we decided, and the President Clinton was about to arrive, and we decided to get mad about that, although we knew. And this was actually the poor ambassador, who is now at the University of Michigan teaching there, is a dear friend, ended up being, kind of chastised by Mike McCurry, just because the President of the United States was about to arrive in the country, and his ambassador was saying that there is. So this is the question, but what we knew then, what's the difference maybe, what you just mentioned, and I wanted you to comment on that, because that's what I find that is so positive about Brazil. Now there are judges in Brazil saying, yes, we do have corruption. It's not endemic, it's systemic, and we are fighting it. I just wanted you and Judge Massetti, maybe the ambassador, say some final words about this, and what about any other comments you can make, because after this we'll have coffee here across the hall, and if you want to talk to Judge Moro, he'll have some more time with you and with the people in the other room. We had about 500 people following us over the internet and in the two rooms, but Judge Moro, would you want to make some final comments, including regarding our dear friend Melvin Levitsky, the ambassador?
Well, as I said in my presentation, I think there's two ways to look to the picture. Yes, we have a problem of systemic corruption. You can say that based on the cases already tried. But by other perspective, Brazil, and this is not something that, sorry to mention in the third person, Judge Moro is doing, but that's the thing that Brazil is doing. The institution of Brazil and the population of Brazil are facing the problem and taking serious steps in the fight against systemic corruption. I think this is very important because it shows to us that there is a possible light at the end of the tunnel. As I said, it's not granted that we will get there. We have to work day by day. And the Brazilians should not wait only the government authorities, the judiciary, the legislative, to deal with the problem. It's a work for all the population. So that's it.
For me, the most significant thing as a judge hearing Judge Moro is this. He says, I look at the cases, and it doesn't matter whether the person is from the left or the right or the center. There's a law to apply, I apply it. And the rest is history. That's the way it works. No special favors, except for foro privilegiado. Ordinarily, no special favors. Just apply the law that you have without fear or favor, without regard to public opinion. You do your job. That's why this man is particularly impressive. He really does deserve everybody's thanks around the world.
Sure.
Well, first I would say that while I was ambassador, I did not speak publicly about endemic corruption in Brazil. I left it for Brazilians to understand and characterize for themselves. But I really come back sort of to where I started, that I think that Brazil is going to be a winner for having gone through this process. As I mentioned, I think the other day, President Obama's first chief of staff famously said in 2008, 2009, whatever, a crisis is a terrible thing to waste. And largely you do not get significant reforms, reforms that are needed unrelated to corruption and so forth, or legal systems relating and legislation relating to corruption, except on the heels of crises, things that really bring it home to public attention, to legislators, and puts public pressure on our public leaders to take action. So I think this crisis hopefully will provide the opportunity will be taken to change things. As you say, companies, I think major companies are going to behave rather differently. Multinational companies will be looking with interest at increased investment if it's easier to do business in Brazil in this regard and otherwise. And I really do think that others are watching, other countries are watching. Mexican colleagues and friends have commented recently that we need our own Lava Jato. And as has been said, we're not free of challenges here in the U.S., as people might have noticed.
Okay, and let me just add one final word, because it's what we attempt to do here is to explain Brazil in its complexity, with its virtues, with its problems. I always tell people we do self-criticism, we do not do self-flagellation. We face our problems. I think Judge Moro, the prosecutors, our colleagues from the federal police are examples of good public service to Brazil. Actually, I have a personal story that I love. I have a grandniece that was born actually 25 years ago at Sibley Hospital here in Washington. Did law school in Brasilia, passed the bar in her last year in school, didn't know what to do, did this and that, and her mother tells me now that she studies 10 hours a day, every day, has done it for the past 10 months because she wants to do she wants to be one of two things, either a public prosecutor, a federal prosecutor, or a federal judge. The exam is very tough. Her name is Livia, and I think you are one of the people responsible for her study. So, having important role models, that's very important, and we thank you for that. You are all invited to join us here across the hall for a cafezinho, cafezão, and bolachinha.
Very nice job. Very nice job.
Obrigado, querido. Obrigado.